Hey guys, how's it going? So recently, my good friend John Crump of AmmoLand broke the story that the rare breed triggers have been deemed a machine gun by the ATF in a cease and desist letter that they sent to that company. Now, lots of people have reported on this since then on YouTube and other places, which is awesome just to create general awareness and to try to get all of the Second Amendment supporters to rally together to fight against this because in my opinion, and by the way, everything in this video is just my opinion. I'm not a lawyer. Nothing should be construed as legal advice whatsoever. Just me hanging out with you guys and opining, basically, right? But look, in my opinion, clearly, the rare breed trigger is not a machine gun. Now, with so many people reporting on it and this news coming so quickly, unfortunately, there appears to be a fair bit of misinformation that is being spread around throughout the YouTube community and other places. And this is just an attempt for me just to do my part to try to help dispel just a couple of these myths, just so people don't get sent in 100 different directions. And I don't want to see people getting too confused or too panicked. And I know Crump put out a video about this earlier, and this is just me doing a little more follow-up. So I'm going to do a little mini series of videos on this, talking about a bunch of different aspects of the rare breed trigger, the experts they consulted with, many things. But in watching a video by a content creator that I really like, that I've met in real life and is a very nice person, they said something that I thought was a little bit startling and needed clarification. So during the rare breed triggers video, they talked about the fact that bump stocks, which, let me back up, unless you're living under a rock, you probably already know, were banned by the Trump administration. To put it bluntly, Trump came out and said, I don't like bump stocks, get them gone, ban them. He ordered the Department of Justice to do so. Through the Attorney General, the ATF, they were deemed machine guns. In my opinion, completely wrong decision. Bump stocks are not a machine gun, and period. But that's just my opinion. But then in this video I was watching, they said, well, now bump stocks are legal and people are freely shooting them at ranges and having a good time. They don't care, whatever. Look, guys, I wish that was the case, but unfortunately, that's just not true. So the court case that was probably being referred to was this spring. The United States 6th Circuit Court of Appeals, this is a federal court located within western Michigan, had overruled a lower federal district judge, I believe out of Kalamazoo, Michigan. So here's what happened, guys, because just follow me here, because it gets a little confusing, but it's really not, even though this is all nuts, because we shouldn't even be dealing with this. So when the federal, we'll call it bump stock ban, because they were made machine guns, but the registry was closed in May of 1986. There's no way, unless you're a special type of FFL, there's no way for normal people to register these bump stocks, so they were banned by practical matter, okay? So that's what I mean by the bump stock ban. They weren't technically banned, but they really were, because there was no way to register them. Destroyed, turned in, whatever is what they ordered you to do. Okay. Gun Owners of America sought an emergency injunction in federal court and said we need to stop the enforcement of this ban because it's unconstitutional. The bump stock's not a machine gun, and we're going to prove that. Well, the original lower federal court disagreed with Gun Owners of America and said no. And they cited and used, and this is the government's argument, something called the Chevron deference. Now, the Chevron deference was from a 1984 Supreme Court case, and this was Chevron USA Inc. versus Natural Resources Defense Council Inc. And it's basically a doctrine. It's become known as the Chevron deference. It holds that a court may not substitute its own opinion in the place of a reasonable interpretation made by an administrative agency. So what they were interpreting was the National Firearms Act, which defines a machine gun, and that one shot, if it expels more than one shot with one function of a trigger, it's a machine gun. So pull the trigger once, brrr, machine gun. Pull the trigger once, bang. Pull it again, bang. No matter how fast you do it, not a machine gun. That's how most of us read the National Firearms Act, okay? Well, the original issue in the federal district court, the reason why they denied GOA's injunction on this federal bump stock ban was they said, look, we can't opine on this. The Chevron deference, which is Supreme Court precedent from 1984, states that if there's a reasonable government agency interpretation, the courts can't really opine on it or overrule it. Gun Owners of America disagreed, and they appealed to the United States Sixth Circuit Court of Appeals. So this is the court that's above that lower federal district court. Now the Sixth Circuit, just in case you're wondering, that applies to Michigan, Ohio, Kentucky, and Tennessee. If it makes a decision, that establishes case law precedent only within that circuit, okay? This is very important. So what do? As oftentimes when they hear a case like this in the appeals court, instead of all of the judges in this circuit court of appeals hearing it, they'll pick off a smaller panel. So in this case, they appealed, and the appeal was taken up by a 3-judge panel in the 6th Federal Circuit Court of Appeals, right? Now, out of this 3-judge panel, they looked at a couple things. First, they had to look at the Chevron deference, because that's why originally the lower court said, hey, we can't look at it. We can't opine on it because this is settled case law that the agency makes an interpretation. That has to stand. Judges aren't going to be able to look at it. Until the senior judge of this 3-judge panel, okay, this was a George H.W. Bush appointee by the name of Alice Batchelder. She looked at Chevron and how it should be applied, and she cited a much newer Supreme Court case that was in fact 30 years newer. And this was the Supreme Court decision in United States v. Appel, in which the High Court ruled, and this is a quote, "We have never held that the government's reading of a criminal statute is entitled to any deference." Meaning the way she interpreted that court case was, hold on a minute, the Chevron deference is not for criminal matters. No deferences, meaning no agency's interpretation of a law can override a court's opinion when there's potential criminal punishment on the line, which no doubt there was for the bump stock case. So her and another Trump appointee both concurred, and there was a dissent from a George W. Bush. So in the 6th Circuit Court of Appeals, George W. Bush appointee. So you've got basically 3 Republican judges, if you will. 2 of them agreed with GOA, 1 dissented. So GOA won the bump stock case in the 6th Circuit Court of Appeals 3-judge panel. And they did win, but kind of. And I hope you're still listening, because this is why bump stocks still haven't been made legal again, and you're still not free to shoot them on the range, even if you live in Michigan, Ohio, Kentucky, or Tennessee. Because what they did is, after they basically struck down the lower judge's decision and they said, yes, we do not need to apply Chevron deference to this, then they looked at the merits. I want to include this of the case. They read the NFA's definition of a machine gun, and they said, no, a bump stock still requires you to pull the trigger regardless of what the shooter's body's doing. The trigger's still getting pulled every shot. And I'm summarizing, guys. Therefore, the bump stock's not a machine gun. This is all great, and this is still awesome. We need to win this case, because this can affect every other case that's going on right now. Not just these rare breed triggers, but also things like reclassifications of frames and receivers, the braces ban or reclassification as SBRs that they're proposing. These are going on right now. This all hinges on this. Can Chevron deference be applied to criminal cases? And that's why this is so important. So the GOA won. We won, if you will, but not so fast. Before it goes to the Supreme Court, there is one more step that an appeal can be granted to. And instead of this 3-judge panel, the United States government could request an en banc panel, an en banc hearing, meaning all of the 6th Circuit Court of Appeals judges. I don't have it in front of me. I think there's 15 or 16 of them, but the point is much more than 3. So what they did is, as soon as the 6th Circuit Court of Appeals 3-judge panel made this ruling in favor of GOA, instead of putting it into an effect, okay, they actually put a stay on their own order. So kind of like paused it and held it without enforcement. I'm just trying to use common verbiage. If there's a lawyer in here, you want to correct me, I'm just trying to put this in plain English, okay? So look, they put a pause on their own ruling to give the federal government time to come back and appeal. Now it ended up being, I believe, in June, just a couple months later after this decision. This is 2021. This is all recent. They did appeal. The federal government, it was granted in June that a full en banc hearing, so all the judges are going to hear it. So right now, since that's been taken up by the full 6th Circuit Court of Appeals, the lower 3-judges panel's decision is vacated, and for all intents and purposes, whatever this full body of judges in the U.S. 6th Circuit decides, That will become case precedents or law of the land. But still, even if we win that, which I hope we win, and I'm very optimistic, and we need to win this because of the other ramifications potentially that I talked about earlier. This is the now becoming the bump stock deference and the bump stock precedent, and this is all really, really bad news. Look, even if this full panel comes back and says, yes, we agree, the district court got it wrong, and just in layman's terms, bump stocks become, quote, legal again. That's still only going to apply to the Sixth Circuit, Michigan, Ohio, Kentucky, Tennessee. And I would note, there's actually a split opinion between circuits. The 10th Circuit Court of Appeals, which holds equal weight to the 6th, if you will, just over different jurisdictions. The 10th Circuit Court of Appeals is out of Washington, D.C., and they've already decided that, yes, a bump stock is a machine gun. So we have a split in the circuits, as they call it. So what does that mean? Well, that would mean that presumably if you lived in Michigan, this is if, hypothetically, this has not happened. I want to emphasize this. Even if the full en banc hearing says bump stocks are not machine guns, okay, you'd be fine in theory to have it in Michigan, Ohio, Kentucky, Tennessee. Definitely not fine in D.C. because they've ruled the opposite. All of the other districts throughout the country, let's just say you live randomly in Indiana, that's not in the Sixth Circuit. No, it's the decision by the ATF. Their ruling, their executive fiat law is still going to stand. Well, there's really only one way to settle split circuits, and that would be the Supreme Court. Then it would have to go to the Supreme Court, and then if GOA wins that, overruling the ATF's decision, saying that's unconstitutional federal rulemaking, right? And that the lower courts had gotten it wrong in the 10th Circuit, and then they would say agree with the 6th Circuit. This is all hypothetical. We have not even won it yet in the 6th Circuit. Then it would become binding case law. Then bump stocks would be, quote, legal in the United States at large. But I would note state laws vary, and there's several states within the union that have specifically banned bump stocks by name. So obviously they would still be illegal in those states because federal law doesn't ban magazines over 10 rounds, but we have quite a few states that do limit them because they've decided that, look, states can be more restrictive on gun rights than the federal government, but not less restrictive. Remember that suppressor case in Kansas? Yeah. And what's going on right now with the potential suppressors in Texas. So, I'm getting a little nerdy because some of you guys like details, but I've been following this case from the very beginning. Like, so the original ruling back in 2018, all the way through following GOA. I'm paraphrasing, guys. I'm not really using notes. I just literally read a couple quotes from these cases. But here's how it stands. Let me summarize. A lower federal district court denied GOA's injunction saying stop the enforcement of this federal bump stock ban. GOA lost. They appealed to a 3-judge panel in the 6th Federal U.S. Court of Appeals. GOA won, but it still didn't make bump stocks legal because they put a stay on their order to give time for the federal government to appeal to the full 6th Circuit judges. The federal government did appeal. It was granted. Therefore, the 3-judge panel that we won at, that ruling was vacated, meaning that's not a win anymore. Now the full 6th Circuit is going to have a hearing on it, and the judges are ultimately going to vote. GOA is putting arguments up right now. This hearing's ongoing. They're currently litigating it, if you will, right? And so as of right now, bump stocks are not legal anywhere in the United States. Should they be? Of course they should be. None of this is what I think should be. I'm just telling you guys what is. Are there people freely using bump stocks throughout the United States? Maybe. Probably. I don't know. I don't care. Just because it's none of my business. I'm not a cop. I'm not a lawyer. It's none of my business what people do. It's none of my business what you do. But just so you know, that 3-judge panel, it was a huge victory because it's all part of the process, but it did not make bump stocks, quote, legal. Definitely not in the United States. Not even in the 4 states that I've mentioned a few times already. No. The full panel of judges, the full body of judges of the 6th Circuit have to decide. And then, if they agree, yes, we don't have to apply Chevron deference, it is not a machine gun, then they'll be legal in 4 states, but they'll still be illegal in D.C. because of what the 10th Circuit said, and they'll still be illegal in states that have banned them by name on state level law, right? And then we'll have to see if SCOTUS accepts the case or what they do from there. I think SCOTUS will take the case if it gets there. We have to win in Michigan's Sixth Circuit, though, guys. This en banc hearing, we have to win, or else we're literally screwed on so many things. But I think SCOTUS will take it. Yes, for the Second Amendment, but that's not primarily why. The real reason I think they'll take it is because several of the current Supreme Court justices have been very skeptical of this Chevron deference, have been even spoken out against it. And I think, in my opinion, just listening to what some of the justices have said, I think they're wanting a case where they can challenge this 84 Chevron deference and try to overturn that. Because from what I've gathered, some of the current Supreme Court justices believe that's bad case law. That it should never be, whether it's criminal or not, where an agency's interpretation allows judges where they're not even allowed to opine. And I'll read you a couple quick quotes here that are kind of pretty cool, actually. So this comes from this senior judge, right, in the Michigan Sixth Circuit Court of Appeals. And she's kind of literally, after she cited that case, she went through and said, Mrs. Batchelder admitted a decision not to apply Chevron deference to the ATF's bump stock ban furthers a critical split with the 10th. I already talked about that. But opined that decisions on criminal punishments cannot be left to bureaucrats and must be left by the public at large. And this is a pretty cool quote. And this is the judge that ruled with the GOA. This is a good one here. She said, "There is a great risk," she wrote, "if the responsibility of making moral condemnations is assigned to bureaucrats in the nation's capital who are physically and often culturally distant from the rest of the country. Federal criminal laws are not administrative edicts handed down upon the masses as if the administrators were God delivering the 10 Commandments to Moses on Mount Sinai." That was literally the analogy she used and wrote that in her opinion. She also raised separation of powers concerns and pointed out that, and this is a quote from her, this is the senior judge on this 3-judge panel, "It is for the judiciary to say what the law is." And this remains equally, if not especially true for criminal laws. So there's a victory as far as the process that it's going to take to make bump stocks quote unquote legal again. Bump stocks are still illegal by this federal, I'm going to call it fiat law, orders from President Trump down to the Justice Department, agency interpretation, rules, federal rulemaking process. Remember that? The comment period, all that stuff, right? Yeah. I don't know what to tell you guys. Do I want them to be legal? Of course. I've done tons and tons of work on my other channel, my 2A EDU channel, about the bump stock case. But no, they're not illegal. And probably barely anybody will see this video, but I just wanted to put it out there because somebody, again, who I really like, who I believe is a really smart person, did come out and say bump stocks are totally legal now. And that's just not true. Now, there's a bunch of other myths going on around, guys, about these rare breed triggers. Some speculations and things. I've gone way longer than I already thought I would in this video, so I'll pick it up, and I promise some other videos I do on this topic will be much, much shorter. And make sure you also check out the John Crump News channel. He was the original person that broke this, and he's going to have more information on this and many other things coming very soon. Alright, thanks for watching, and have a good one.